Hey there, I am Todd Watley, the Elder Law Coach. Thank you so much for joining me today. I'm super excited today. I'm talking about something that, it's not my forte. It's not something that I have distinguished my practice on, but as a coach now for almost 7 years, I have seen this become, it's always an issue. Not always, it's almost always an issue with people. And I think it's something that you can expand your practice tremendously and hopefully give you some confidence. And it is advanced estate planning. I think this was advertised as, there we go. I was going to make that bigger, but I think that's big enough. So, this is advanced trust and estate planning. These are basically 10 different trusts that you need to be very aware of and be able to discuss, and it's solutions to clients' problems. And that's what we do as attorneys. But I just see so many people that they are here. I'm going to do this. There we go. Make that a little bit bigger. I see people that are so restricted by what they do. They do a basic revocable living trust, okay? And here you go. There you go. Powers of attorney, hopefully. But here's your estate plan. And I see that as not solving problems. And many times people, when someone comes in with a advanced issue, something that they're not familiar with, you refer it out. And I don't know if you have a referral agreement, but it's almost always better to keep those cases. You're going to be able to charge more. You're going to be able to expand your practice and do things. And today, I want to introduce you to these concepts, okay? I can't in 1 hour make you an expert in these, but stick around to the very end. I do have an event coming up in June that I want to talk about at the very end of this to truly help you get this under your belt and help you to truly feel confident doing these different types of deeds. Or deed, where'd that come from? Trust, okay? So let's get to it. Revocable living trust is obviously the first tool that we use, and it's one of the things you learn it in law school. It's very common, and estate planners know that a trust is what a lot of people need, okay? It helps solve a lot of problems, complicated distributions, being able to hold assets for a child, and just solve pretty much simple problems. Your basic day-to-day client coming in, they're not wealthy, they just want to avoid probate, and they have either minor children or they're now grown children, but they don't trust them with money. I mean, there's just a lot of things that a trust can do, and I think you understand that. One thing that I have found in my own office, okay, and that I see a lot of other attorneys don't do very well is the trust isn't funded. And so jumping to something that I think is a problem, could be a problem, is funding, okay? If the client's trust is not funded, everything goes through probate. There's really nothing that the trust does. If you did a pour over will, it will pour it into the trust, but that's after everything goes through probate. The whole purpose of this is to not go through probate. And I see that as a huge problem. People come to see me saying, hey, mom and dad died. They used this attorney. I've heard you speak. I want you to look at this. And it's like, great, there's a trust, but what's in it? And they're like, we don't know. And come to find out, really nothing is in the trust, okay? You will get a copy of these slides. I apologize, this does seem a little small, but I will get you a copy of these slides. So, the issue is assets are never retitled, okay? And if you're telling your clients to do this, and that's all that you're doing, I can promise you, many times it is not getting done, okay? It is simply not getting done, and you have to make sure this gets done. I've hired someone in my office. Their job is the funding coordinator. After we have the documents done, signed, when they come in to pick up their documents, they meet with my funding coordinator who gives them letters and paperwork and goes through this and once again reinforces the importance of making sure your trust is funded, okay? And her job is to audit this, to say, hey, let me know this has been funded. And I'll be honest, she doesn't have great success with that. And it's not her fault. She is sending out the emails. She is getting people to do this. And we're doing our best to let people know you've got to do this. This is absolutely important. And letting them know the RLT is the hub to your whole plan. You've got to make sure this is funded. And I heard someone use a great analogy. It's like your revocable living trust is your car. Okay, we just created this beautiful, fantastic car that does all these fantastic things, and it's safe, and it's fun. It just does all this. But if you don't put gas in it or you don't plug it up, it's just going to sit there and it does nothing. Okay. And so, you've got to encourage people and enforce upon them. You've got to fund your trust. Okay. And I'll say, if you're not auditing the funding, you're not really doing estate planning, because the plan that you've created for this client is going to fail if it is not fully funded. All right. So drafting's great. We do that. We have software to do that. But plans fail when the trust is not funded. Okay. It is just hugely important. And I encourage you to up your game if you're not following up with clients and making sure things are funded. All right. Enough of that. I know. The next trust that I think some of us don't fully understand, and probably if you don't understand it, you're not doing it, is a credit shelter or a marital trust. We are seeing nowadays so many late in life marriages. People, particularly as an elder law attorney, so many times the spouse passes away for both people and they come together, and now they have his children, her children, and if they were younger when this occurred, they have their children. So it's his, hers, and theirs, or his, and theirs. Whatever the situation may be. And their situation is going to be more complicated. I did a complex meeting yesterday where mom's living with son and new daughter-in-law. She's 60, he's mid-60s. They just got married, and now mom's living with them. And the new daughter-in-law came in and paid for half the house, paid off the mortgage so that the house was free. And she has children. Husband doesn't have children, but there's some nieces and nephews that mom wants the money to go to. A deceased child that had children, and we want to make sure that everybody gets to live in this house, but then at the final of these three people's death, half goes to one child, or half goes to the nieces and nephews, and half goes to her children, plus her assets. She wants to benefit him, but then go to his children. I'm just like, oh God. So, that's a very complex situation, and we are seeing that more and more, and this is where the credit shelter marital trust comes in to say, hey, while you're both alive, everything's fine and dandy, we can manage this, but when one of you passes away, here's what happens, okay? We do a marital trust, which makes sure this money goes to the kids, or is, held separately. The spousal trust, she needs money, or, the surviving spouse needs money to do things with. And so this is a way to protect it for the kids and let people know this is going to be protected for the kids, but also give the spouse some freedom. And you have to understand this and be able to present this to the clients and explain it, okay? I know most of us have good software, and if you don't have software, we probably should talk about that. But there's some good software out there that will do this for you. But if you can't explain it to the client and you don't really understand what's going on within the software and the language that is produced, this is going to be a problem, okay? When someone calls you on it and says, hey, explain this to me, and you're like, yeah, I'll get back to you on that. No, that looks terrible. You've got to be able to explain it. You've got to know it. You need software to do it, but you have to be able to explain it. And so that's where this comes in. If you can't explain it, they're going to go hire someone else. All right. So the bypass marital trust essentials. It is asset control after death. Okay. It's a way to do this by having one surviving spouse typically be the trustee and possibly bringing in another trustee to make sure things go well. And what I see is I'm dealing on a case for another attorney that when the first spouse dies, the bypass and marital trust was never funded. And then the surviving spouse did some crazy stuff, leaving most of the stuff to one child to the exclusion of the other child. And so the excluded child has lawyered up, and they've now called me to say, what do we do? And so I see so many times things don't get done following the death. And you have to understand this, and you have to get the people to come back in and see you and say, hey, when one of you dies, you need to come in and we need to do this, what this trust says. And so many times that doesn't get done. The blended family, okay? Even doing this with just both couples' children, that's complicated enough. But then when each one has separate children, that's when things really get interesting. And there's ways, how do you fund these trusts? There are different formulas to do this. And probably one of the most flexible ways is the disclaimer. And for one spouse to say, nope, I don't want this. Let's put this over here. I do want this. Let's put it over here. That gives a lot of flexibility rather than trying to predict this when both spouses are alive and sometimes 10, 15, 20 years prior to death, trying to predict what's going to happen 20 years from now when one of us passes away. You don't know who owns what or where or how much, or you're just guessing. And so disclaimer is a cool way to do that and account for the current situation. Again, here we go. Funding, auditing the funding is important, and it's particularly important here, okay? With not funding a joint revocable living trust between two long married couples is not great, but eventually, if it goes through probate, it'll end up in this trust, and then that's what happens. But when you don't do the funding correctly, and this is that second case I was talking about where I'm working with this I'm working with this attorney whose client did not get a fair deal, and there's some problems, and this did not get done appropriately. And so you have to audit the funding and make sure things get put into this trust that you're now creating for the benefit of a surviving spouse and then separate kids later on. Funding here becomes super, super important. Let's get to one of my favorites, okay? Special needs trust. If you are not familiar with special needs trusts, how they work and who they should go to, you are missing out on a tremendous benefit, not just helping clients, not just financially, but just the heartfelt appreciation of parents of a disabled child to say, yes, we've taken care of this. I know my child is going to have money, but also is still going to be on Medicaid, because many times with a disabled child like this, Medicaid provides a tremendous benefit dollar-wise. Okay, I mean, I've seen benefits in $20,000 to $30,000 per month of benefits that Medicaid is providing, and having them in a special facility, a group home. There's just things that these families work years on to develop and get in place for their disabled child. And then one of them passes away and this special needs trust is not done. It could be devastating to this family. Okay. It's like, wait, this is not what this is bad. I would rather not have the money and keep the Medicaid. But if you don't do things right, their Medicaid's gone. And you have to be careful with that. And a special needs trust is absolutely the way to do this, to be able to protect the money for the child to benefit from the cool things that the money can buy them that Medicaid won't buy them. Okay, Medicaid pays for basics. A special needs trust pays for what I call the fun stuff. And it is truly avoiding a catastrophe by making sure this money goes where it needs to go, and the person still gets their benefits. And these families are so happy. And we can go into this later, but when we know there is a disabled child, I mean, obviously all of your trusts needs to have a contingency special needs trust provision so that if a child at the time of this person's death is disabled and on Medicaid, their money goes into a testamentary special needs or a subtrust special needs trust. But if we know there's a beneficiary who is on Medicaid and will always be on Medicaid, I like to do a freestanding special needs trust, and that's a whole nother webinar within itself. But when we do this freestanding special needs trust, it's sitting out there separate from the revocable living trust that you've done, and it's able to accept funds from other people also. The parents, obviously, they want to leave their share to this child, but maybe a grandparent, maybe an aunt or uncle, maybe some friends. They don't have children, and they know their friend's child is disabled, they may want to leave them money. And so a very simple tweak to their estate plan to say, hey, a beneficiary of our estate plan is this special needs trust, it's done. And now this child gets more money, more fun things to do, and still keeps their Medicaid, okay? So special needs trusts are just crucial. You need to understand there's a third party and a first party, okay? Very quickly, third party special needs trust is when a separate individual leaves money to a disabled child. It's not the child's money, it's my money that I'm leaving to that disabled child. That would go into a third party special needs trust. A first party is when the child's money themselves, they've gone through a lawsuit. They've received an inheritance, like we just talked about. It's like they get this money, or then they have to put it into a first-party special needs trust. And you're like, well, Todd, you just said if we don't set this up and money goes to them, you can do this first-party special needs trust. Yes, you can. It's something messed up. Yes, we can do it. And the downside to a first-party special needs trust is you have to pay the state back for the care that this person received, because it's their money and the state's letting them stay on Medicaid by putting this money into a trust that will reimburse the state for their care. That is not the case with a third-party special needs trust, okay? With a third party, it's my money. I'm choosing to leave it to this disabled person, and therefore, since I'm making that choice, the state can't get their hands on it. It's not their money. There was never an issue with this, with the state allowing us to do this. I'm choosing to do this, and therefore, when this special needs trust person dies, special needs trust beneficiary passes away, I can now leave this to a charity or to my nieces and nephews or whatever. You can leave it anywhere that you want to. And that's why the third party special needs trust is so much better. A first party is, here's, something's happened and we're forced to do a first party special needs trust. You always want to do a third party if possible, and particularly with the inheritance, if that trust can be up and standing when this person passes away, their trust plan says this money doesn't go to the disabled child individually, it goes into the special needs trust, which allows us to do a third party rather than a first party. Okay, retirement accounts. It's beautiful for a retirement account to go into a special needs trust because it can be seen as a pass-through, and there is one designated beneficiary. It meets the IRS guidelines, and it's just a beautiful tool to use. I would think there are attorney liability risks that if you know this is an issue and you as the attorney don't advise the family to do this, I don't know how you get out from under that. You should have known that. You should have taken care of that. And so it's just, number one, it's a super neat tool, and number two, you should be doing it. Okay, so one wrong beneficiary designation can cost the family everything. Okay, if they're getting $20,000 or $30,000 worth of benefits and now they've got to start paying for this, bad news. Okay, I did not go into this when I talked about a revocable living trust, but spendthrift and discretionary trust are the sub-trust. I don't know why this keeps switching back and forth. I'm not sure if you're seeing that or not. It keeps going from. Anyway, a spendthrift and discretionary trust. My revocable living trust that I do for every single client, if they're leaving it to children or people, a person, it doesn't have to be a child. If they're leaving it to a person, you want to leave it into a discretionary spendthrift trust. That way it is protected from bankruptcy, divorce, and lawsuits of that child, all right? And so this is I don't see this as a trust. I see this as the provisions of a trust, but it's one of the things that you absolutely need to understand, and it is insurance. It is insurance for the parents to know, I'm going to leave this to my son, and my stinking daughter-in-law can't get to it, okay? Or if she leaves him, this money will stay with my son and not go to my daughter-in-law. Or, my daughter is not really good with money and I want her to benefit from it, but I want someone else to be in control of the money. So there's some really interesting things we can do there that protects the money and decides who's going to be in control of the money. And if you're not familiar with spendthrift or discretionary trust, again, I almost think this is malpractice, because if you create a revocable living trust and you leave the money outright to the children and they are going through some legal issues at that point in time and they lose the money because you did not create a spendthrift or discretionary trust for the benefit of that child, I don't know how you get out from under that, okay? I don't know how that is not malpractice. I don't know how they can bring a claim against you to say, now, I do understand privity of contract and like, to my knowledge, in Arkansas, a client's child can't sue me. That may have changed recently. I don't know. I just don't want that phone call. I don't want that meeting with the child to say, could you have done something? I got my mom's money and I had filed bankruptcy just before mom and dad died. And now I've got this inheritance and it's now being taken by the bankruptcy court. Was there anything that you could have done to fix that? And if the answer is yes, even if you're not getting sued, that's just a bad day, okay? And it's so easy to fix. Most of the software programs now allow you to include a spendthrift or a discretionary trust in the trust. So the issue here is why this doesn't work is if a creditor can get to the money. If the beneficiary can get to it for any reason whatsoever, then a creditor can do that. And here's a point here. So many times clients come in and tell me, they're like, hey, I want to leave a lot of money to my kids and I want them to get, $50,000 a year. Okay. So every year the child gets $50,000. Can we do that? I'm like, yeah, we can do that, but you don't want to do that. And they're like, why? It's like, well, because if you have a mandatory distribution from their spendthrift discretionary trust, if you have a mandatory distribution, the creditor can see that and know that. And if it's a mandatory distribution, it has to go out. Boom, the creditor grabs it. And so when people tell me that and that we're trying to create a plan for them, I say, I understand that, but why don't we just let the child, or if you're doing that, you probably don't trust the child with money. And so let's just have whoever you name as the trustee of this trust, which is not the child, we can say it is our preference that they be allowed at least up to $50,000 for health, education, maintenance, and support, and purely discretionary if they need something else. And so doing the purely discretionary versus discretionary, that's something for a much longer lecture, which I'll bring up later on. But doing a mandatory distribution means the creditors can get to it. So basically, if a creditor or judge can predict when the beneficiary is going to get the money, they can grab it. And so we don't want to do that. We want it to be discretionary. We want it to be have a spendthrift provision to say, nope, they only get it under certain situations. All right. I love Medicaid, and Medicaid is one of the places where you can truly make a difference in people's lives. I had a brother and sister come in yesterday, and her husband is going into the nursing home, and this brother and sister just inherited 2,400 acres. That just blows my mind. It's like, I have 30 acres, and I'm like, God, this is a lot of land. I cannot imagine 2,400 acres. And they came in distraught saying, are we going to lose this? I'm sure we're going to lose this. Surely there's no way someone can qualify for Medicaid and us have 2,400 acres. I'm like, after some questions, she actually lives on the property. So yes, we can protect 2,400 acres. But what if she didn't live there and they had 2,400 acres that had been in this family's possession for generations, and this land was. He said, I'm going to bring you some deeds that are from the 1800s that show that we've owned this land since the 1800s. I thought, well, that's going to be kind of cool. So thankfully she lives there, and that fits under the Medicaid exemption. If she had not lived there and she owned this was going to be a huge issue. This is where the Medicaid Asset Protection Trust comes in. Now, if you've done some seminars, webinars with other people, and you've learned about the MAPT, you're like, fantastic. This is the tool to use for everyone. And it's absolutely, yes, this is fantastic. It's like, nope, don't get too excited. I've done a podcast, and I encourage you to go to my podcast, go to my website, theelderlawcoach.com, go up to podcasts, find the episode on MAPT, when you should not use it. My position is, and I think I'm right, is that an MAPT is rarely used. Okay? Because there's some huge downsides to it. There are issues that you need to be aware of. Now, I do tend to be fairly conservative in this, and I want to make sure that I don't put someone into this and this thing blows up on us. From what I hear people doing, from potential coaching clients, and I see on Facebook discussions and just different places, listservs, people are like, yep, Medicaid Asset Protection Trust, this is what they blah, blah, blah. And I'm like, no, it's not for everyone. When it's the right tool, it's a beautiful tool, but so many times it is not the right tool. And this is where you integrate estate planning into Medicaid, and it's just a beautiful situation when it works and when you do it correctly. And 5 years from now, after 5 years from now, someone goes into the nursing home and we've protected a large portion of their assets. It's a great tool. It gives me chills right now to think, here's what I did for this family, and they are protecting everything. But it's not for everyone, okay? There's some controversy, okay? Across most of America, when you do the MAPT, you can have the income go back to the grantor or the trust creator. I tend to be very conservative because I'm in a state that is very aggressive in making sure things are accountable assets. And I don't do income. Okay, I don't do income back to the grantor. Income does need to leave the trust for tax reasons, but I don't have the income go back to the grantor because I'm afraid our state will see that if a grantor has the benefit of income, they will want to make this a countable asset. I know that doesn't follow federal law. I know that's not the way it should be, but I'm just telling you, if the state says, yep, we don't like it, we deny, you've got to go through the whole denial process, and that's probably 2 years if we lose at the fair hearing and then get into court. And by the time we get into court and argue it in court, and the judge who knows nothing about Medicaid has to listen to our arguments and then do some research and then finally issue an opinion, it's going to be 2 years from the date of denial. And I don't want to go through that. And I would rather be more conservative and say, absolutely, this works. No income, no benefit. I know that works. And there's the 5-year look back. And you really should not be pulling assets from this trust and giving it to the client, even in the roundabout way that we do. And if you don't understand that, I can discuss later. But I want to make sure that other than very extreme situations, we can get through this 5-year look back. So many people are doing these trusts saying, if we need the money within 5 years, we can get it back. You're just asking for troubles. You're asking for your state to come down on these and say, yeah, these don't work, because we've seen a number of these trusts where the money did actually go back to the grantor, and therefore if it can go back to the grantor, it's a countable asset. It's not protected. So go listen to that podcast. It's probably one of my most popular podcasts as far as downloads, because that's very interesting. I think I tend to be a little contrary to most people, but listen, if you disagree with me, email me, Todd@theelderlawcoach.com, and say, hey, listen to your podcast and I don't agree. Okay? And if you do agree, please let me know. Okay? I enjoy some affirmations, but I can handle the people that's like, yeah, I don't agree with you. Here's why. Let's discuss it. Okay. I'm absolutely not above discussing if you disagree with. All right. So that is a Medicaid crisis or pre-planning tool. Okay. There are some crisis tools. Someone comes into your office, just like the couple yesterday, he's going to the nursing home. We have acreage. We have money. What can you do for us? Here's what I can do for you. I can save everything. If they're married, I can save at least 50% if they're single. And if that interests you, and if you want to know much more about crisis planning, I have a Medicaid transformation weekend coming up in September of 2026, and I would love to see you there. Come to Bentonville, spend a weekend with me, and you will leave there being able to at least understand what's going on and hopefully implement that into your practice. But Medicaid crisis is kind of, it's hair on fire. Things are important. Things have to be done very quickly. But to me, it's the most satisfying area of practice because people think they're going to lose their entire life savings. And after an hour with me, it's like, nope, you're good. We're going to protect it all. Those people are very thankful. Okay. So if a loved one's going into the nursing home, there are some trust and things we can do. Not the Medicaid Asset Protection Trust, except in very rare circumstances, particularly with the crisis. Yes, you can do it and still get through the 5 years, but you need a ton of money to do that. I'm talking about a Miller Trust. If you're in an income cap state, you need to do a income only trust that's under federal law that says, here's where we can put this money. Sometimes you can put money into a pooled trust, meaning there are excess assets and we're going to put it into something like a special needs trust, but it's not a large amount of money. You can put it into the pooled trust and they will hold the money. You can now qualify and get onto Medicaid. But again, since it was your money and it's now being protected, the state or the nonprofit who is running the pooled trust is going to get what's left over. So it's not a great solution. It's a solution, but it's, and then this is not a trust, but we many times use annuities for crisis planning. When we are doing a crisis plan for a client, the way we're able to protect upwards of $1 million for a married couple is with the use of an annuity, a very specific Medicaid qualifying annuity. All right, so very quickly, crisis planning principles. You're a problem solver, okay? You're not just drafting documents. There are deeds and different things we need to draft. You can draft documents, but you're a problem solver. These people come in and just dump this huge issue of, oh my God, my husband's going into the nursing home and we have $1 million and we've worked very hard for this and we don't want to lose it. Can you solve my problem? Yes, ma'am, I can. Okay? It's best job in the world, okay? And we go from spending it down. Many times the advice of non-elder law, non-Medicaid planning attorneys is, oh, you just need to go spend it. You can spend it on the nursing home. You can go buy some stuff. But yeah, you've just got to spend it all. That is not the answer, okay? We do some spend down, but we're able to preserve a large portion of the assets using different tools. And knowing how to do that is so important. And many times there are trusts that do that, all right? There is a huge ethical guidance here. There's so many myths of Medicaid. And what really aggravates me is people go to an attorney, and to super aggravate me is they come to my presentation at events. I'm speaking all the time saying, yeah, we can do this and this and this. We can preserve $1 million with a married person and blah, blah. And, I go through all this and then they go to their attorney that they've always used. And it's like, hey, I've heard you can do this. And that attorney's like, oh, yeah, I think you do that, blah, blah, blah. And it's totally not the plan. It doesn't preserve the assets and it's just totally messes everything up. And sometimes those people think, well, I guess Todd doesn't know what he's talking about because my lawyer didn't bring this stuff up. Okay. All right. I love this phrase that I created. It's like, this is where you go from drafter to problem solver. Drafting documents is okay. It solves problems, but it's typically not immediate, crucial, very expensive problems. Now you can rest better knowing that your assets are going to go to your kids without going through probate. Okay. Yay. That's good. But when A client walks in the door hearing from everyone else in the world that they're going to lose everything that they have because their loved one's now in a nursing home. This is where the real problem solving comes in, and it's immediate, it's impactful. It's like, yep, I can help you today. Okay. All right. So what about the married client? Okay, we've talked about a trust for the married client, but what about your married clients with money? Okay, substantial amount of money, and they are wanting to protect some money from the evil government. Okay, and a spousal lifetime access trust is a way to get money out of your estate, but still have somewhat access to it. Okay. Basically, you give the money to your spouse, gets it out of your estate, and then the spouse is in control of the money. Okay. And you can actually do reciprocal. They can't be exactly the same, but you can do reciprocal slats so that you're getting this money out of your estate and giving it to someone else. And then hopefully that spouse will give you access to that trust, or give you access to what's in the trust, not to the trust, but they can pull money out. The spouse has lifetime access to the assets in the trust. And if you're like, hey, let's go to Italy for a month, she can pull the money out of her trust and pay for y'all's trip to Italy. Okay. And so it's a way to get the money out of your estate for tax reasons, to lower your taxable estate, without completely getting rid of it to someone that may not give it back to you. Now, your spouse may not give it back to you, okay? This is great marital counseling here to say, we're going to do this, but y'all really need to stay married and you really need to like each other to make this work, okay? And so this is a very interesting tool that typically is for your higher net worth people to give money to basically each other and then be able to still access it. Okay, it's a really interesting tool. Okay, another way to not cause tax problems or to alleviate tax problems is with life insurance. But remember from law school, life insurance is part of your estate. And so many times there's a lot of cases published out there where someone has died and they had a taxable estate. It's like, well, they have $15 million. I don't feel sorry for them because they should have money to pay the taxes. Oh, the poor kids didn't get the full $15 million. They had to pay some taxes out of it. Well, I get that. However, what if there's not money to pay the taxes within 9 months of your death? Okay. So many times people have $15 million worth of stuff, but not money. Okay. If you own 2,400 acres, okay, this previous client, 2,400 acres, it's probably not worth 15 million, but if it was, how do we pay the tax on that? How do we give Uncle Sam their share of the estate tax? How do we give the state their portion of the tax? We don't have any money. We have to sell property. And this type of property, to get it listed and sold and closed within 9 months could be very difficult. And you don't pay your bill within 9 months, the penalties and stuff starts happening. You have life insurance. Okay, well, good. If I have life insurance that'll pay me $2 or $3 million to pay this tax, well, great. Well, without the life insurance trust, irrevocable life insurance trust, that $2 or $3 million further increases your estate, causing you to pay more taxes and needing more money. And so the ILET fixes that. So basically, you buy an insurance policy within an irrevocable trust that is not part of your estate. And there's a lot of paperwork that goes into that to make sure that it's done correctly, that everybody's given notice, and to follow those very strict IRS guidelines to say, this is not part of my estate, okay? And so now you die, the ILET gets $2, $3, $4 million. The people can take this, the kids take this money, pay the government, and say, leave me alone, okay? I think the Miami Dolphins owner owned the football stadium he was well over the taxable amount, but the family did not have the money to pay the taxes, and they had to start selling stuff very quickly, which is never good. All right. Then we get into dynasty trust. These are your very wealthy people that really want to preserve money for the next generation and the next generation and the next generation and even the fourth generation. And you'll see here, protect for 4 generations. I've done a lot of research on this and read a lot of things, and you've probably seen this, okay? We have people now who probably grew up in the Depression, and they have been very good with their money. They have invested, they have created businesses, and they generated a lot of money. And when they died, they left it to their children. Well, the children were part of that. They possibly saw the parents as being poor and generate this money, grow this money, and they appreciate that. They're like, we saw our parents work very hard to go from nothing to multimillionaires. And they appreciate that, and they honor this money as being the hard work of their parents. And if it's enough money to pass to that third generation were the grandkids, who may or may not have spent time with their grandparents who created this, and probably rarely spent time seeing how the money was built, and they don't appreciate it. They just see that their rich parents have now left them money and they're trust babies, and they go off and they enjoy the money that their grandparents built, and rarely does the money get past the third generation. And it's kind of interesting. I'm seeing this play out. I'm in Bentonville, Arkansas, Walmart country, and a lot of the Waltons still live here. And the grandchildren now, the children of Sam Walton, they're billionaires, and they've appreciated this money, done very well with their money. Now they are leaving it to the grandchildren, and the grandchildren, you can always tell. There's an airport about 3 blocks that way, a small airport, not a big airport. It's a small airport, and a few times a week, this loud noise, this plane takes off, it's super loud, and it's up and it's flying around. Well, everybody knows that's the Walton grandkids. They bought a World War II plane, and they've learned to fly it, and typically there's 2 or 3 of them out there, and they're always doing stuff, okay? They've built trail, mountain biking's huge up here, dirt trail mountain biking is huge. They've built lifts, the money is just going. I'm sure there's enough money there to get to the 4th generation, but most of your normal wealthy families, rarely does it get past that 3rd generation. And so here we are helping the people who have created this money, who have worked hard, and maybe their children who really appreciate the money, helping them make this money get to the 4th generation. Typically, if you can get to that 4th generation, you've created a mindset, a family dynamic that appreciates the money and grows the money rather than just blowing it. So if you can get to that 4th generation, chances are this family is going to be okay. But it's hard to get to that 4th generation, and so that's why we are protecting the money for that 4th generation. All right, this is how you stop planning for 1 generation and start planning for 4. So if you wonder why 4, that's why. All right. So, grantor trust, okay? There's some really interesting things we can do with what's called an IDGIT, grantor, blah, blah, blah. I just drew a blank. But it's a grantor trust, irrevocable trust that the grantor is still under the IRS, you're mapped, okay? The Medicaid Asset Protection Trust is typically a grantor trust so that you can get tax benefits, but under the Medicaid rules, the money's gone. And so you're creating some very interesting situations by creating grantor trust. It's a very powerful tool, particularly for taxes, all right? And so that's something that you need to understand. You need to understand taxes to get there. All right, key takeaways and actions, okay? Funding. You've got to make sure your trust get funded because it's the gas for the car, okay? And if you don't gas up the car, it's just a really interesting stack of paperwork sitting there doing nothing, okay? Your more wealthy clients, they want to integrate their planning for not just their kids, but their grandkids and great-grandkids. And so being able to understand and appreciate what they've done and know the rules, the tax rules, the estate planning rules, being able to transfer money to generations, that is crucial. And I want you to understand that. Okay. And choosing the right trust, protecting, and it's not just for the kids, it's while your clients are still alive. Sometimes people bring to us very interesting situations, like my situation yesterday with the mom and son in the house, and the daughter buys half the house and wants that money to go. That situation, it's like, oh geez, you have to be able to provide some really interesting tools for these people. Now, here's the real gap in estate planning. Here's what I'm seeing, and here's what I'm trying to fix. Awareness. I know this is out there, but being able to implement it is a huge gap that so many of us don't ever jump. Okay, I see attorneys, I feel really good with revocable living trust, I'm just going to do that. If it's anything else, I'm just going to send it out the door. Well, when you have multiple millionaire clients, they're willing to pay a handsome fee for you to solve their problem. And you sending those out the door is not healthy for your bottom line. You're able to help more people, to provide really interesting tools and profit from that. Okay. So, comfort zone. I want you to get into the comfort zone of being able to do these trusts, be able to create the trust. Number one, recognize when the trust is needed. Number two, create it. And then number three, be able to explain it to your clients so that they will hire you to do it. Okay. That is a very narrow path that I want to help you get down. Okay. When your confidence drops, I can just see it in my coaching clients. It's like, hey, what about this situation? And you just see them go, well, yeah, I'm not sure. Okay. That's low confidence, and you're not going to do a good job. When your confidence grows, okay, the moment a case gets even slightly complex, that's where confidence drops off. Okay. You're like, oh, this is outside my comfort zone. I'm not going to do it. When confidence drops, opportunities disappear. You're like, yep, not going to do this. I'm going to send it away. How good would it feel to be able to sit down with confidence and be able to meet with these people and solve their problems? You're going to miss opportunities. You're going to have to send more cases out the door to other attorneys, and that's just truly lost revenue. Okay. So, complexity. These things get complex. There are a lot of things you need to understand, and it's hard to learn those. Okay. Again, I'm going to get you these slides, and I'm doing my best to get us out of here in under an hour. So, I want to take you from drafter to estate planning architect. Okay. Being able to truly sit down with these problems and create. I am amazed at a blueprint. That just blows my mind how they can look at every brick and every 2x4 and the electrical and the plumbing, and it's just like that took some brain work and computer power, but brain work to put it in there to say this is how we're going to build this apartment complex or this sky rise. Okay. You're going to go from just basic run-of-the-mill documents to a true estate planning architect who can solve complex problems, okay? I am doing an estate planning transformation weekend. It's June 12th through the 14th. I want you to come to Bentonville, Arkansas. It's beautiful here, okay? Particularly June. It's not too hot. It's beautiful. There's some really nice things to do here, but I want you to come and sit down in a room with me all day Friday, all day Saturday, and probably more than half a day on Sunday. We're going to do some intense work. We're going to get you from drafter to being able to implement this in your practice and truly transform your practice by doing estate planning the way that it should be done. This is not just another CLE. I don't want you to just show up and sit back and be working on office things. I want you to come engaged. I'm limiting this to a limited number of people who are truly motivated to come here and transform their practice by doing this. There's going to be discussion. There's going to be fact patterns. It's me teaching you this, and we're going to sit in a small room, a few of us together, and go through this and go from where you are today to a really good estate planning attorney, being able to recognize the issues, know what the tools are, and be able to explain it. Okay, it's implementation, not just theory. I've gone to so many courses where they're like, oh, here's the blah, 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 and here's the blah, blah, blah. And you leave there and you're like, Okay, I know what it is, but I have no idea how it fits into my practice. This is going to be implementation, all right? Small group. I'm limiting this to a select few clients who want to come and truly learn this step by step all the way through, okay? You're going to learn step by step advanced plan design. How to explain this to clients. That's the number one thing, is getting your client to understand it without overwhelming them, and threading that needle of too much information will scare them off. Not enough information won't persuade them to do it. There's a fine line. Okay. Comfortably quoting fees. I think after this weekend, you can raise your fees, and I think maybe substantially raise your fees to accommodate what you are doing for these people. Okay. And I want to introduce you to elder law, Medicaid into your practice so that you can help more people and be able to implement some of the more advanced planning from elder law, Medicaid into your estate plan. Estate planning clients are simply pre-Medicaid clients. They get old and they're going to need help later on, and I want to at least introduce you to Medicaid so that you can help us Medicaid people when you do an estate plan if you don't want to do Medicaid, but then hopefully come back in September and do my Medicaid course where you will leave there knowing Medicaid start to finish. Okay? Who will thrive? Attorneys who master these strategies. You've got to be able to learn these strategies, and I spend hours on this, okay? It's all day Friday, all days. And I say all day, I mean like at least 8, if not 9 hours, okay? We're going to try to have a little bit of fun in the evenings, but we're going to spend some very intense days in the classroom learning this stuff, okay? So if you're ready for more, I encourage you to get in contact with us and take your estate planning from the basics to thriving with some complicated case that you can charge appropriately for, okay? Your next step, join us in Bentonville. Okay, you'll love Bentonville. Everyone who comes here says, man, this is really cool. I was not expecting this. And let's help framework your practice so that it will grow and implement this stuff. Okay, you don't need more information. The information's out there. ChatGPT, Google, you can get the information, but how do you make it work is you need clarity and confidence. And that's what I want to give you, is the clarity and the confidence to do this correctly. Once you have that, that changes everything. Okay? Are you ready to transform your practice? Come see me. Okay? And it is June 12th through the 14th in Bentonville, Arkansas. All right? Okay. Thank you so much for joining me. I encourage you. Hopefully you can see it. Man, that blue on green's not great. Trisha, Trisha, at theelderlawcoach.com. Very simple. Email address, Trisha at theelderlawcoach.com. She is my contact for scheduling. If you're just curious if this would help you in your practice, please get with Trisha, schedule a phone call. I would love to meet with you, discuss this so that we can talk one-on-one and figure out if this is going to be something that's going to help you in your practice and truly transform your practice. And then hopefully you'll join me in September for the Medicaid course. Okay. Thank you so much for joining me, and I will see you next time.